8 of it. Could tell serial numbers. 8.
Yes.
Lord, matter pertaining to my Lord Dr. Shivram Karant layout, my Lord. I'm sorry, my Lord. I'm moving on the administrative side. For this reason, there is a serious threat of my Lord. Constituted, my Lord. There is a serious.
Then you move the register judicial.
Lord, I'm sorry, my Lord. I have moved thrice, my Lord. Lord, the last week I have filed. There is a serious threat of dispossession, my Lord.
Let it be routed through the register judicial.
I have moved before the, my Lord, Honorable Registrar.
Your number will look into it. What do you want? Placement of the matter.
For tomorrow, my Lord.
That is, don't know. Get it.
See, if during vacation, my Lord,
You can move vacation. Always you can move.
It is a special bench. My Lord. It is a special bench constituted.
Be constituted. Yes. Be constituted.
May I request for
tomorrow? At the earliest. We don't know when, but at the earliest. Yes.
Request for tomorrow, my Lord. If
tomorrow may not be possible. Tomorrow being the last day may not be possible.
Hello,
Yes.
May I give the.
I will give the number. Take the number of. Yes.
Hello, this is a PIL to free.
Convey to register judicial to meet. Yes. Yes.
The PIL to frame guidelines on perjury, my lord.
There is no urgency.
The court has.
There is no urgency on the last but one day.
The only concern is that the court will have time during vacations to ponder upon it. There are several judgments of the Honorable Supreme Court and this court.
We ponder upon only when the matter comes upon.
It can be taken up today or tomorrow, my lord. Once only to see the petition notice is issued.
No. Sorry. Yes.
On matter at 2:30, my lord, there is some urgency, my lord. The appellant is challenging the order of the election commission, my lord. The appellant is running the educational institution in which, my lord, they are conducting the Guru Vandana program at Puttur, my lord. For the said program, my lord, initially permission has been granted. Subsequently, my lord, it has been cancelled. Now, today evening, my lord, Sri Swamiji is visiting the campus to the school, my lord. So kindly have it at.
So I didn't get it. What is the urgency?
The felicitation function to Sri Swamiji of Sringeri Math, my lord, at Puttur, one institution at Puttur. So the land single judge has rejected my writ petition, my lord. Due to the
felicitation function is held.
Yes.
So what is
initially permission has been granted. Subsequently, my lord, it has been withdrawn. Now, all of a sudden, it has been withdrawn, my lord. We have invited Swamiji and there is some urgency, my lord.
Nothing like that. So, how that is.
Okay. No urgency. We can't treat this subject matter.
My writ appeal will become infectious, my lord.
Become sometimes, so it can be done. For felicitation, you should be allowed and matter should be taken out of turn. That's not, that will be really bad.
It is only the Guru Vandana program, my lord, not more than that.
You will be laying a very bad precedent. You have great respect for the Swamiji which you have mentioned. That's another thing. We cannot lay a wrong precedent.
My sincere apology for moving this.
One submission, my lord. Only they are saying that code of conduct is there. So for that reason,
only thing that we are not permitting is urgent circumstances. You move the court in regular course, you can move the vacation judge, whatever.
Today evening is the function, my lord.
You can reschedule it. We don't know about the function and date. And yes.
Lordship, my sincere apology moving this manner, Lordship. This appellant has suffered a brain stroke, Lordship, and his body become paralyzed. He's under trial, Lordship. His bail, we have moved a medical bail, Lordship, because it's a subsequent bail, the matter has to go to the earlier bench only. And because of the difficulty, the same bench is not sitting, Lordship. So I already had tried before the Registrar General, even the senior bench also, Lordship. The urgency is there, Lordship. It's because it's a medical urgency. He cannot do any regular work of his own, Lordship. His entire body has got paralyzed, Lordship.
On administrative side, we looked into.
Lordship, we already moved it twice from the past 2 days. I am following it up,
I'll
Lordship.
look
Either
into it.
special order may be passed to place it before the regular bench.
I'll look into it on the administrative side today itself.
It's end of the list. I am requesting, Lordship, because the emergency is there, Lordship.
What emergency?
Medical emergency, Lordship. His body is paralyzed. He can't. His entire body, half the body is paralyzed, Lordship.
So
And he is in judicial
ask the-
custody for that reason only.
In the recess, we'll take a
Obvious.
call.
My lord, suit for recovery of money is filed by respondents, my lord, against a partnership firm. My lord, I had taken a specific contention that I have already retired long back from the firm. Yet, my lord, the suit is decreed. My lord, challenging which I have preferred a commercial appeal, my lord. My lord, I have also asked, sought for a stay, but my lord, it is not listed. In the meantime, my lord, today, my lord, they have secured a delivery warrant.
Go before the appropriate bench and mention, taking up the commercial matter.
My lord, what happens, my lord, is since, my lord, in the commercial appeal, I have sought, today morning, Aminas have come, my lord, and they are sitting at, today morning, my lord, the court Aminas have come to the house.
But there is a bench,
There is a bench taking up
there is a
commercial. matter.
dedicated bench for that.
Please, my lord.
You have to go
Mention there.
What can we?
It's a commercial appeal, my lord.
Goes
It
before
is
the
not to come here. It will come before
other bench.
another bench as per the roster. Yes,
Please.
no, after.
Now they want to take position on the based on the portion data.
We'll take back if you are successful.
Otherwise, they take the land in your, there is, they have to collect it for the lot of, not from the position. But, the preventive.
We don't see any urgency after vacation.
My
Yes,
lords, I am the petitioner in person, this fresh PL matter. My lord, the matter is regarding contamination of drinking water in the state, especially in northern Karnataka, my lords. It's a fresh matter filed last month.
after vacation.
Anyone, date after.
Date
Because
will
it's
not
are filed last month.
It will be,
Fresh
it
matter.
it will be listed once you remove the office objection.
Yeah, everything is done, my
Then it
lord.
will be
That
listed.
is-
Don't worry. Get it listed at appropriate time. Yes.
Any date after. First,
No date. It will be listed.
Fresh matter.
It will be listed, Mr. Party in person. Keep it.
It's not been listed.
When you file it,
1 month back, my lord.
1
It's
month
been
back.
month because
list it on 10th of June. Yes.
Standard petition, my lords. The complainant and the accused have been divorced by the mutual consent agreement in the year 2019. Joint custody has been agreed upon regarding the minor child. However, it's been 40 days. Accused, the mother, has been absconding. There's no connection with the child, hence the urgency, my lords. It's been
You
more than 40
Move
days.
learned vacation, Judge.
My lords,
You can move learned vacation court.
tomorrow, my lords. Kindly, it's been more than 40 days, my lords. There's no touch at all.
But on the
Just
last day,
mother-
all of a sudden you are coming.
Kindly, my lords. We have tried moving the.
40 days got over when?
Yes.
My lords.
40
Days
days,
are over now.
Yes, my lords.
when it got over.
My lords, since March,
So then,
we have filed it in March, my lords. petition.
so on the
However,
last day, you are cropping up the urgency, propping up the urgency.
Kindly, my lords.
Vacation, Judge, you can move.
Matter of urgency,
Vacation, learned vacation.
please, my lords, tomorrow. Thank you. The father has not seen the child.
We can understand that the
Special child. my
40
lords.
days are over by tomorrow or yesterday, but that is in March. What were doing all these days?
Lords, we tried moving the memo, my lords, however, it did not get listed.
Will permit you to move the vacation.
Kindly, my lords, it's a humble submission. my lords.
So permitted to write on that, permitted to move the vacation judge,
Tomorrow, my lords.
subject to persuading learned vacation judge for urgency.
And the question was dismissed on again. Now the respondents are trying to take the position of the body. Because 1 month before I have filed it, there was a lot of officer. He has complied. Then the other maybe taken up tomorrow.
Not
They will take the position. It is 89 notification, but till now there was litigation. Original suit was pending and in RF.
If urgency is really pressing, then move learned vacation judge. Yes, yes, madam.
Sir, it appeared of 2022, my lord. Matter was supposed to get listed on 18th April, but there is one impleading applicant counsel who is not complying with the office objections. Because of that, it has 4 connected matters, my lord. So after vacation and date meeting.
After.
A complainant retired professor. Pensionary benefits not settled. And he retired in the year 2022, my lord.
almost 2 years over, my lord. His pensionary benefits not separate for aided period service. From 2 years now without pension. Maybe have it immediately after first week of June.
12th June. Yes,
And
yes, Mr.
I'm a party person. I filed a contempt petition. It has not yet been posted.
To be posted after vacation.
in the environment compensation case, Lordship said no precipitative action to be taken. But it appears by mistake that is not typed. In all other cases, it is,
It matters, there was precipitative action.
how? In all other cases,
That's
environment
environment
compensation.
compensation.
Yes, yes.
In yesterday, one matter we added it. We noticed that it is not transcribed.
It appears to be added, just verify. It is added yesterday.
Yesterday it is added.
And on the
Or-
left out was.
On our own, it is added. If still anything else, you can mention. Please.
Serial number 48, my lord. This is,
48.
need the adjournment
No urgency. No, beyond.
after the vacation.
So it is good that you are mentioning for no urgency.
After the vacation.
It is a second rate petition on the same.
Let us.
Yes, madam, what is?
My lord, serial number 28. I'm appearing for the petitioner and I want to file a withdrawal memo, withdrawing the petition. If I may be allowed to make a small submission regarding this. Contempt petition.
You want to withdraw?
Yes, madam.
Withdraw the petition.
28.
Contempt petition.
Learned advocate, Miss. What is your name?
Gamini Rajagopal.
For Bhargav, but
Yes, ma'am.
seeks permission to withdraw the contempt petition. Permission is granted. Dismissed as withdrawn.
Much obliged.
Memo is submitted.
Yes, memo is submitted.
Seeks permission to withdraw the contempt petition by submitting a memo containing instruction to that effect. Permission is granted.
Much obliged.
Contempt petition dismissal. Yes.
Serial number 49, request for a short account. Serial number 49, personal difficulty, request for a short account.
After vacation.
Serial number 51, my lord. June judgment has been passed by one of the members of this learned body. The Muligini
matter. Decided that.
It will go to along with the group.
Yes.
We posted at least just before some urgency in this matter.
Which one? This?
We posted the earliest date may be fixed.
It is already fixed.
Please, in the same matter, serial number 51.
Other than. Oh.
Please, please.
8.
60 minus.
65. What do you want?
You have to file a reply affidavit. Date will be given after.
Filing reply. File it. Nothing to be made.
It is complied.
Serial number 52, my lord. I am appearing for the contempt complaint, my lord. Filing memo for withdrawal, my lord.
52.
Complaint, my lord.
52.
52, my lord.
Complaints happened.
Complaint, my lord.
Your Keshava, but
I am appearing for Keshav Bhatt.
learned advocate Mr. So and so appearing for learned advocate Keshava, but stated before the court that the order order brought under the contempt jurisdiction of this court is complied with. Therefore, according to his submission, nothing survives in the contempt petition. In view that the statement is made about the compliance by the complainant, the contempt proceedings are disposed of, has not survived.
Serial number 34, my lords. Serial number 34. I appear for the accused, my lords. I request for the matter to be posted soon after vacation, my lords.
34, what do you want?
I appear for the accused, my lords. I request for some time, my lords, soon after
Beyond
vacation.
vacation.
Great.
My lordship, serial number 22, my lordship. I request a short account. 22, my lords.
Appear for respondent.
Short.
22.
Yes, my
Please.
lord.
So what do you want?
Short accommodation. my lord.
Time
Yes, ma'am.
beyond vacation. After 10th June, all matters after 10th June.
Please. Serial number.
Yes,
53. TF to
Yes. Yes.
Serial number 81, my lord, will be adjourned.
Adjourned,
Sister for
adjourned.
final hearing.
It will be adjourned.
Please, my lord.
2017,
Yes, my lord. Hearing only the last,
keep it on 3rd of June.
please.
Serial number 53.
50, 53,
3 weeks time, 2 weeks time.
all granted. 2nd July.
Lord, serial number 76, Lord. 76.
76.
76, Lord. Serial number 76. I need to comply office objection, Lord.
On time,
Time, Lord.
beyond Vegas.
Lord, interim order may be granted, Lord.
It will
Interim
be
order is granted, may be
it will be
extended.
extended. 27th June. Interim relief already granted shall continue to
Please.
operate till the next date.
Please, please, Lord, please.
For that.
So we dismiss the writ appeal of fraud in relation to gift deed will be confined to be read in respect of the breach of condition only. It will not be a fraudulent transaction in that general sense of that much clarification in some paragraphs here they laid down according.
Contempt matters, seal number 2, Ajit Kalyan.
Regarding to the complaints of the my lords, the Anand Singhal judge order, page 14 and serial paragraph 17 is the relevant portion of the housing board was directed to execute the seal deed, my lords.
Notice.
I accept for art.
You are for R2. R2.
Mr. Mahindra accept for art returnable on 26th of June.
26. Seal number 3, Mr. Padmanabha R.
My lord, order is at page 14. Annexure
Page
B.
16.
Page 16, my lord, the relevant. In view of the above, this writ petition disposed of in the same terms as has been done in the opposite. The another writ petition, my lord, is at annexure C. Direction is contained at page 21.
Page 21.
Item 7, my lord. The respondents are directed not to interfere with the lawful recreational activities carried on by the members of the petitioner. In spite of the direction issued, my lord, in spite of the legal notice, they are insisting upon, my lord, the obtaining of license and also interfering with the recreational activities carried on by the members of the club. It is contrary to the direction issued by this. Even, my lord, the legal notice also issued, my lord.
Notice returnable.
I accept for R8.
R8.
27 June. Notice also kept, question of limitation is kept open to be considered on the next date.
Appear for the complaint, appear for the complaint. Madam.
Yes.
Order is at annexure B, my lord, page 20. The complaint, who owns land, 20 guntas of land was acquired for the formation of the road under the guise of public purpose, my lord. And 20 guntas road has been formed. Thereafter that they have, as promised, the TDR was not issued. Annexure B writ petition was filed, page 20, my lord.
First July.
You are for first respondent, Mahindra. You are for first respondent.
Yes, for R1.
Mr. Mahindra will accept for first response.
Good. Lord, in this matter, we have complied.
Marigowda,
Complied with.
Complied.
Complied with.
Compliance affidavit is also filed.
Learned advocate, Mr. So-and-so, so the complainant could not dispute the statement made by learned government advocate, Mr. Mahindra, that the order under contempt is complied with. In that view, the proceedings does not survive and stands disposed of.
number 6. Ganpati Bhatt.
Yes.
Inquiry number 34, my lord.
What is it?
This is, my lord, direction has been issued to transfer kata in the name of the petitioner. Inquiry number 34, my lord, is
34.
34.
They have not given kata, has it?
Kata has not been issued. And we are subsequent to this order, my lord, that we have given representation, copy has been submitted.
Consider representation.
Notice on
I
25th.
accept notice for
25th of
R5.
R5.
learned advocate, Mr. Mahindra. For number 5.
BBMP. BBMP maybe.
Notice has to go by through police under the rules.
Number 7.
This case, my lord, order is at page number 21. The respondent 4 and 5 are directed to pass fresh general award within 2 months. Order is, my lord, is dated.
They were supposed to.
Please.
Same date, 25th June.
R5. my lord.
R3.
R5.
R5.
Three.
State of Karnataka is R3.
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 R1, R2 and
R3.
Number 8. Kumariam.
Violation of the Section A, order dated 15/12/2023.
Degree certificate. Notice returnable on 29th of.
Kindly issue the notice to respondent, my lord. Kindly issue notice to the respondents.
29th May.
Number 9. Green bench matters. Govind Raju case.
I am for the petitioner in this case, my lord. In this case, my lord, the license is granted to extract the sand from the river, my lord. Instead of removal of the sand from the river, they are extracting the adjacent Gomala land. That, my lord, the river was flowing in the U shape, my lord. From long flowing of the water, there was a dibba formed that was treated as a Gomala land, my lord.
This is PIL.
Yes. That photographs I have produced in 114, my lord, page number 114.
To whom you had given the representation?
That geologist I have given the representation, local authorities have given the representations, my lord.
So the license is given in respect of this land falling in the middle.
Yes.
Yeah.
Sand gets accumulated. Inside engineering, everything.
Actually, issue notice.
And may I make a submission? This sand.
This is total non-application of mine, prima facie. From the photograph it appears.
No, there was a notification issued.
That's all right, but the area beyond the notification is the bone of contention.
No, it is for the state agency, KRDI.
You will not do anything, therefore, in other matters, there are 2 such matters already. I do not remember the numbers. There are already 2 such matters.
Lord, it is in stream mining, I can understand. Lord, there was a notification issued by the sand mine, district sand mine monitoring committee.
Anyway, he has raised a complaint which is pregnant with public law elements, public interest also.
There is
Therefore,
a
you file your
vented dam situated upstream and down, please.
want to spy.
We'll see. I'll give you. 5th June, 6th June,
Till
6.
date not to extract, my lord.
Right now, we will not grant it.
Seal number 10. Ravindra Gajanand Kolle.
Please, my lord. Rule 42(3) came to be amended effective from 17/3/2023, my lords. Calling upon the query lease holders to obtain and install GPS-enabled services, one state, one GPS, and also register under Integrated License Management System, ILMS, for the first time. Pursuant to that, a notice came to be issued, produced at Annexure A, my lords.
Any similar matters we are considering?
Now, one matter was filed and
My
withdrawn.
lords were
Whereas-
pleased to
We're asking-
interfere.
We are asking him, if you know, you tell. If
Yes,
you do
madam.
not know, allow him to tell.
Okay.
Whether similar matters, I vaguely remember.
Yes.
Having read the similar patterns.
One state, one GPS matter, Lord, we opposed. After arguing some time, Lord, the council withdrawn the petition.
It can be for this bench itself,
Yes, Lord.
possible, in the very beginning.
Yes. And so far as you last may kindly see, the first prayer, page number 44. A declaration is hard.
Number 40.
Where is that gazette notification? Let us. D.
2794 notification, which is the page? Notification referable to that annexure D.
Annexure D.
Is there, page number 66, my lord. Annexure D.
And how?
Why is such a declaration?
So the issue is, my lords, on an earlier occasion, my lords have passed some interim
No,
orders.
that is probably not the question. Why such declaration you need?
Yes, my lord, because herein, those,
Any ambiguity in this notification?
yes, my lord.
What is
The
that?
whether crushed material falls within the definition
Not
of.
there, we can't read nor we can add. If it is not there, not there. If it is there, it is
Yes,
there.
sir. Only based on that rule came to be amended. Rule 42(3).
So this crushed material and mining sand are not notified minor mineral.
Yes, ma'am. That is my contention. The notification which the state government is going to rely is of 1994. If building stone is extracted from the mother earth,
Any granite work,
or whatever the
basalt,
grade.
gravite, elite, sandstone, so and so, of any color, texture and structure. If these words go together with all these, then the crushing.
Also
part will
becomes,
also-
it also, it's a very.
It is like saying,
They have taken up agistum generis.
quarrying of building stone shall be building stone only, not any other product at all.
Therefore, any derivative is also in that only. It's a agistum generis.
sorry, my lords, my submission is quarrying has been notified this time in KMMC rules at annexure, at page, at section, rule.
The crushing part, the crushed material will not be different in the characteristics. and
Yes, my lord.
Derivative.
Derive it.
Apex court said in an excise matter, by applying rule, I do not remember that, it's ex nihilo nihil fit contra. Apex court said, if X is the focal point of a notification, any derivative of X will also fall within the penumbra of notification. These are the words of the apex court.
Yes, sir, I fully agree with that proposition.
Yes.
But here in this notification, the words used are which cannot be quarried and extracted. So if it is extracted from the mother earth, then only it can be called as ordinary building stone. Otherwise, no, that is one thing. Second thing, use of the words sheltered. Sheltered. Yes.
What is your submission?
My submission is, herein it is removed and taken to stone crushing unit. Therefrom, state is demanding or regulating that your transportation should be through a vehicle which is fitted with a GPS instrument. The state doesn't have such powers in view of decision delivered by Honorable Apex Court in MPP Kaveri Chetty case. The powers of the state to regulate ceases as soon as royalty is paid and mineral dispatch permit is obtained. Mineral dispatch permits are issued to a place from the mother earth or quarry pit to a destination. Thereafterwards, they can't exercise control.
I'll reply.
Where is
Elaborative reasons for treating this as.
And here ordinary building stone and minor minerals are defined by central government under section 3E of the MMDR Act. It is a delegated legislation, subordinated legislation. What is provided under the main enactment can only be enforced by the state. Herein all powers have been assumed. After filing their.
You have first to come out from the basic concept.
Please, my lord.
Then
Please,
go to
my
the
lord.
delegated legislation.
Please, my lord.
Notice, 25th of June.
In the meantime, some protection to me that.
No. State needs protection from your client.
Seal number 11.
Please, my lord. Herein, I am the petitioner owning a stockyard license, which came to be withdrawn in the year 2010, my lords. Now pursuant to an order passed by Honorable Apex Court, which is produced at Annexure A, relevant para 30 at page number 39, my lords, which I have called out in my writ petition, my lords, at page number 6 of the writ petition.
There is a violation of the Apex Court order.
No, I pursuant to this order, I am permitted to lift the stock without reference to or without recourse to e-auction platform.
Your prayer,
yes,
your English prayer,
yes,
is specific.
Yes, my lord. May I read, my lord?
Yes. First prayer.
Issue a writ of mandamus or any other appropriate order or direction commanding the fourth respondent chairman of the monitoring
To
committee.
immediately comply with the explicit directives passed by the Apex Court in so and so.
Yes, yes.
So you want implementation of the directives of the Apex Court. Whether Apex Court said any High Court can be moved to implement our orders, as it has said in many matters. Which is that order?
I think in that explicit terms, it has not been said.
Wherever
Yes.
Apex Court says that the citizen is entitled to go like under the Asiad matter, etc. There is a series of such matters. If there is such a direction, then you can approach this court. You can't complain before the High Court about violation Judgments are there. If there is violation of the apex court direction, there are two aspects. It's one best book considered, Professor Lakshmi Kanta had considered that. If the apex court declares law, like 141, or if the apex court makes norms, as it was done in Visakha, then you can come here. If the apex court makes directions which do not have repetitive expectation of compliance, then your remedy lies before the apex court.
But I am not on the point. I may kindly be permitted to read
Consider
that.
your representation.
Yes, consider my representation and
consider this
in terms.
Consider the
Central Empowered Committee.
Annexure E is my representation, my lord.
Your committee. Consider his representation because Article 350.
There is a separate
mandates.
There is a separate council for representing CEC.
Party here?
It's not a party.
Yeah, the party.
It's a party.
Yes.
Article 350 says, as interpreted by this court and Madras High Court, wherever citizen raises a grievance in writing, the authority is bound to give redressal this way or that way. That having not happened, he is here.
Yes.
Fourth respondent is chairman and convener, monitoring committee.
Has to consider the representation.
Yes, ma'am.
Fifth respondent is member secretary of the committee. 4 and 5.
You are appearing?
You are
No, I
appearing?
am not
Yeah.
appearing. Notice may kindly be.
Who, any standing counsel is there?
Earlier, Lord, one Keshav Reddy was appearing, Lord, now he become additional government. Age.
In light of this one.
In light of this order, if it is pending, reach the present copy of this order, and will send response, answering response. We need not issue it. Very innocuous order. Deciding the issue.
Third learned advocate, we are asking you to go there and directing number 2 to decide your case.
Your representation.
Your representation.
Please, my lord.
Third learned advocate, Mr. Ravindra Gajanan Kolle for the petitioner and learned government advocate, Mr. S.S. Mahindra, appearing for respondent state of Karnataka and its authorities. So the case will be considered by the monitoring committee.
By the monitoring committee.
Respondent number 4 and 5.
4 and 5. You are not appearing.
I am not appearing.
By filing this writ petition on Article 226 of the Constitution, the petitioner seeks direction against respondent number 4. There's the chairman of the monitoring committee, chairman and convener of the monitoring committee, Department of Mines and Geology, as well as against this one of 5, the member secretary, Central Empowered Committee, to comply with the directives directions issued by the Apex Court in order dated 20th/5/22 in IA number 205 of 14 in writ petition into bracket civil number 562 of 2009. The petitioner thereby wants the respondent authorities to permit the petitioner to sell SEWL or dispose of the royalty suffered stock of old iron ore owned by the petitioner. Paragraph. It is the case of the petitioner that the stock of iron ore has been lying at licensed stockyard in survey number 108 of Jambunath Ali village, Hospet Taluka, Bellary district. Paragraph. The petitioner submits that the permission to dispose of the stock is required to be granted. Else, the stock will suffer loss in the value and will further result into degradation in quality due to environmental factors. In support of the prayer, the decision of the Supreme Court in Samaj Parivartana Samudaya versus State of Karnataka, in writ petition civil number 562 of 2009, decided on 20th May 2022, is pressed into service. More particularly, the following observations in paragraph 30 of the order. Correct? 30.
Please, my lords.
That apart, my lord, there was a criminal case was also filed and he has got an acquittal. However, he has got an acquittal for illegal transportation of mineral also. It is produced at Annexure B.
We'll record it. 30 of the order, which is as under then quote paragraph 30, page 39. While relying on the aforesaid submission, it is the case of the petitioner that the aforesaid observations of the Honorable Supreme Court applies to its case, and in that view, the petitioner should be permitted to dispose of the IR and IRA. Full stop. This court, however, has not gone into deep to ascertain whether these observations apply in RAM in respect of all similarly situated petitioners. It is for the competent authorities, respondent 4 and 5 herein, to examine the same paragraph. While we relegate the petitioner to respondent 4 and 5 to consider the case and the grievance of petitioner, learned government advocate submits that there have been an instance whereby the petitioner has been convicted.
Acquitted.
Acquitted for
an offense of illegal transportation.
Then what is relevant? If it is acquitted, what is relevance?
Lord, so far as the stock to the extent of Lord, illegal transportation of stock is concerned.
Acquitted of offense in relation to?
Relation to Lord, illegal transportation.
Illegal transportation.
Of 8,008
Full
metric
stop.
tons of iron ore.
Full stop.
I have produced the judgment of the.
According to learned petitioner, the aspect of acquittal is material to be considered.
We, at this stage, we do not know, Lord, whether an appeal is filed against this acquittal
Acquittal in
order.
respect of the illegal transportation of the mining material.
Okay.
Full stop. Again, this aspect is comma, whether this aspect is relevant to the controversy involved is to be considered for the competent authorities in its length and breadth. Full stop. Having noted the controversy and the grievance, comma, the court deems it fit to require the petitioner to approach respondent 4 and 5 with his grievance and the prayer raised in this petition. Once the petitioner approaches the said authorities, comma, the authorities shall consider the grievance in accordance with law and pass appropriate order within period of 8 weeks from today.
Please, my lord.
3 months from today, 3 months from today, 12 weeks from today. Full stop. It is observed that this court has neither gone into the merits nor has expressed anything on the merits of the case of the petition.
Okay.
We'll take the hand summons, Mr. Hand summons is permitted of this order, whereby the petition shall serve the copy of the order to respond to 4 and 5 authorities.
Number 12.
This case, my lord, I'll take 5 minutes. My lord, this is the writ of mandamus which we have sought. Volume 3, my lord, inquiry number 466 annexure L. Volume 3. 466, my lord, annexure L. This is, my lord, 3E application, my lord. Since, my lord, originally, my lord, query is granted by observing all KMMRC rules. Subsequent to that, my lord, new mineral found in the query list area. Thereafterwards, that we have approached the authority by submitting application. Then, my lord, a procedure has been followed and the recommendation has been made by virtue of direction issued by this honorable court. Thereafter, kindly see 466. This is 9th October 2023. This, we have approached this honorable court. This honorable court was pleased to directed to consider my application within 6 weeks. Operative portion of the order is 471. Last pair. I may permitted to read me.
To take the decision on the recommendation.
Yes. Thereafter.
471. What is 471?
Pursuant.
The third.
Subsequent to that. Subsequent to this order, my lord, the one MLA Ravi Kumar has given a complaint to the Mines and Geology Department saying that there is the single family. Thereafterwards, my lord, director has referred to the matter to the joint director, revisional authority, and revisional authority has submitted a report annexing
Learned
amended.
Advocate Mr. Pat Ganapati Narayan for the petitioner, notice written on 24th of June.
And my lord, if it is directed and disposed of, my lord, by considering, my lord, already report has
May I
come.
make a submission? This is the second writ petition making the similar prayer. Your last may kindly peruse the prayer in this petition.
No, all right. We'll assume that it is second. Did you consider and pass the order is the question?
It is a process, lot. He has applied for a lease, quarry lease. We request,
Let
we
him
have
file a
request-
statement of objection. Let
we
him file.
requested for no objection certificate from the Revenue Department, Forest Department. This was an order passed in the year 2023, my lord. We have issued notices to the concerned department requiring them to give no objection certificates.
But what you are submitting may be translated into your objection.
Objections.
Appeal matters, seal number 13,
Please, ma'am.
Basuraj HT.
Approved by the order of the learner single judge, my lord, dated 14/12/2022, my lord. This writ is filed. The improved order is page number 12, man.
Page number?
12.
Begins at place 1, 2. Similar matters, what we have done? Huh?
First, Millard.
First.
Please, Millard. We kindly produce at page number 16 Millards, or para number 5 and 6 Millards.
There were, counsel, there were similar matters.
JP Nagana, but
My
here
lord, they
this
are
case-
pending, my lord.
They are pending here.
Yes,
No interim order granted.
not to my knowledge, no. It came up about 2 weeks back.
Will issue notice.
Will issue notice.
Notice is on 25th of June.
My lord, I take notice for respondent number 2.
2.
Learned additional government advocate, Ms. Nilofer Akbar, accepts notice for respondent 2.
You appear for first respondent.
And learned advocate, Mr.
Javid.
Javid. Except for number 1.
Sir, copies.
Number 14, Mr. Srinivas V, party in person.
My lordships, I'm the party in person. I have come here before this honorable court challenging the order passed by the single bench wherein the honorable judge has said National Commission for Scheduled Castes has no power to entertain any service related complaints, that is specific complaints. But this honorable court, division bench of this honorable court, has already held in a similar matter that the National Commission has the power under Article 338 to take up any service matter, and the recommendations can be given and it cannot be set aside by the single bench judge.
Where is that judgment?
My lord, I have placed the list of authorities in a memo. In that memo, the first judgment, page number 1.
So judgment of the Supreme Court or this High Court?
This Honorable High Court Division
This High
Bench.
Court. Justice.
Abhay Oka and Justice S.R. Krishna Kumar in the year 2019.
Page number?
It is last.
Writ appeal number 3821 of 2019. It's in a separate memo.
The commission cannot issue positive directions to do this
Only inquiry.
inquiry.
Or recommending.
And the state had filed the writ petition against me, my lord, saying that the recommendations, they accepted their fault. The additional chief secretary himself said that there is an issue in this and we will get it sorted. But still they came upon to the single judge and they got it quashed, my lord. And the single judge has not even considered one point of my objection also, my lord. So it's an already well settled law that it has been said where Article 338 of Indian Constitution confers the power to the commission to inquire into specific complaints regarding any with respect to deprivation of rights and safeguard, any kind of this thing which for
How can commission issue a positive direction? Which
not a direction, my lord. It's not a direction. It's a recommendation. It is not a direction. But the Article 338 clearly says that after inquiring into the specific complaint, when the commission gives the recommendation, it shall be placed before the legislature of.
The commission expects that the recommendation is implemented within 15 days. Therefore, learned single judge have faltered the same rightly.
My lords, this fourth time they have come for that, and that is the reason the commission says that it has to be
power. If they do not do for 3 times, on the 4th time, the commission can issue the orders having implementation effect. Where is that?
In this only they have given it, my lord.
Where is your relief? Where is your relief in the main petition? Your
Sorry?
prayer in the main petition.
Prayer in the main petition is.
Where is the prayer in the main petition? Let us.
1.
Pages are not.
No, it is not.
The writ petition or the writ appeal, my lord?
Writ petition.
My lords, they have not, the government, when they produced us a copy also, they have not given the prayer. It was done in a very haste, my lord. It came up before the single judge and single
petition without prayer.
My lord, I'll verify, my lord. It's coming up for the first time. I'll take notice.
It's already a well settled law, my lord. So only I'm not like, he has just said the commission doesn't have the power to come into service matters, but already this honorable court has said in the division bench judgment.
My lord, page 54.
No, just we wanted to know the prayer of your
My lord,
prayer in
that
the
is,
petition.
That is, I remember the prayer, my lord. I read it online. Set aside the recommendation of the commission and the representation given by the respondent number 2, that is me. Both the things has been set aside. I don't know how the representation acts as a this thing. He said it is a complaint and he has set aside that also.
just as at page 54, paragraph 1, my lord.
say, was implemented within 15 days. That is this order itself, page 37.
ಏನ್ರಿ ಇಂಥ ಡ್ರಾಫ್ಟ್ ಮಾಡಿ ಏನೇನು ಮಾಡಿ ಬಿಡ್ತಾರೆ. Now, who has done it?
It is just a recommendation, my lord.
No, it is not a recommendation.
Direction is given.
It is a
That is the last time they have given the direction saying that if it is not considered, we will take it in the other manner, because the 4 times the additional chief secretary has been called. He has come twice, appeared before the commission, and he said, yes, what we have done is wrong. We will rectify the issue.
Chief Secretary is to make them stand as accused before them. And they have seen that judgment, it is observed. Absolutely a piece of power by the commission. Cannot, they will assist the commission.
This is not recommendation.
Order. How government should function if commission were to come and direct the chief secretary, additional chief secretary, come stand like an accused, implement our order. That's not the purpose for establishing the commission.
No, my
Only
lord.
recommendatory, it is there. You are only repeating it. The third time it is there.
Yes, my lord. They gave the
Government
recommendation.
can run. If interference is to that extent, no government can run its business.
But my lords, they have accepted the fault before the commission, my lord. Come and say what they have to say. Instead of that, let them come and say, at least make
The
no.
commission can say anything. We are saying that commission is not jurisdiction.
No, at least let them represent it here, my lord. There also, they were not given any chance to represent.
Why do you worry about their interest? You argue your case. You argued it now.
Commission is only inquiring and recommending body. No
Yes, my lord.
adjudication, no direction, no mandate, nothing is.
My
within the
my
purview.
lords, they had given the same recommendation 3 times.
You are saying it 4 times now.
3 times. The 4th time also, they didn't implement it. That's when they were called again. And when again they said they will come and we will do it, is what they gave this thing. So that time the commission said,
The appellant is original respondent 2 in this writ appeal, whom the court has heard at length. First of the writ appeal is direct against judgment and order dated 1st March 24, whereby the petition filed by the state is allowed, and complaint dated 31/5/23 lodged by the appellant respondent 2 before the National Commission for a Scheduled Caste, and the subsequent proceedings before the commission have been set aside by a single judge. Full stop. The complaint of the appellant paragraph before the commission was in relation to service matter and service related grievance of the appellant. Full stop. The court, it is extremely doubtful. It is extremely doubtful whether the service related grievance could be brought before the Scheduled Tribe Commission, or that it is within the purview of the consideration of the commission, or that it is within the purview of the constitutional petition. Full stop. Even otherwise, when the directions issued by the commission is looked at pursuant to the complaint of the appellant, it is manifest that the commission has traveled beyond its jurisdiction by issuing the directions in the nature of mandate. Full stop. Paragraph. Learn a single judge has noticed these aspects.
my lord.
Paragraph 2 of the order, which reads as under quote paragraph 2. Paragraph. Learned single judge is eminently right. The aforesaid directions are clearly in the nature of mandate issued to the authorities to implement the recommendation of the commission within 15 days. Full stop. It amounts to, it partakes the adjudication and amounts to giving operative directions, which is not within the jurisdiction of the tribunal. Paragraph. Learned single judge has rightly noticed the observations in writ petition number 1 to observation of this court in order dated 6/6/22 in writ petition number 12079 of 22. That in the respect of the grievance of the government servant in the matter of recruitment and appointment to civil post, the remedy is available before the Central Administrative Tribunal under the Administrative Tribunal Act 1985. Full stop. It was eminently proper and legal for learned single judge to come to a conclusion that the respondent number 1 National Commission had no jurisdiction to entertain the complaint of the appellant. The exercise undertaken by the National Commission was contrary to the law and usurpation of US URPTAM of the jurisdiction not vested in it. Full stop. No error could be booked in the judgment and order of learned single judge. Writ appeal is meritless. The same is dismissed.
Thanks, my lord.
Number 15. Pradeep Sauka.
For respondent, if kindly a week time may be granted. I've also filed contempt petition.
Your friend wants time.
Lord, he has also filed a contempt, my lord. Let him not precipitate the contempt.
We will not move up to after vacation.
Let him not precipitate the contempt, Lord.
He says he will not move.
That, let that be recorded, my lord. Because this is against the chairman and
After
managing
vacation,
director.
Lord, both
Now, my
matters-
lord, the disciplinary action has been set aside by imagining grounds which are not even raised in the writ petition. My lord, he does not even say that, no, he gives a complaint, my lord, to the government alleging against maladministration of HAL, my lord, against the chairman, managing director, and my lord, the policy regarding appointment of directors and CEOs. And then, my lord, in his official car, CDs containing sexual content was traced. Now, my lord, inquiry was held. Learned single judge says, my lord, his complaint should be treated as he is a whistleblower. Now, my lord, his defense to the charge sheet is, I have not sent it. Now, my lord, after inquiry, it has been traced to him. It's an anonymous complaint, complaint sent through emails, which has been traced to his IP address. Now, my lord, the learned single judge, even without there being any ground, my lord, holds that it is not a misconduct. He should be treated as a whistleblower.
Request your lordship. My lord,
Stress to him. Beyond the parameters of the itself. Yes. It cannot do that.
What was the prayer in the petition?
Prayer in the petition, my lord, is to set aside the order of the disciplinary authority and the appellate authority and to grant him benefits. In fact, my lord, he has in the meantime retired, my lord. Therefore, we had continued the disciplinary inquiry pursuant to a power under the CDA rules to continue. Then, my lord, after the charges are proved,
It's what I said.
Lord, the
63 and 64. Yes. Third learned, we are staying,
Lord, both the matters can be heard together.
we are staying the directions in paragraph 63 and 64.
They have not given any retirement benefits also, my Lord. They have not
Lord,
given
I have
even
paid the
medical-
entire retirement benefits, my Lord.
We are
medical
not
benefits
disposing
also
of
not-
the appeal is at
Yes,
large. We'll consider. But prima facie, the things are so
Both the matters. can be
unacceptable
heard
in terms
together,
of the
my Lord.
directions.
Contempt and both the appeal also, my Lord. Both the matters can be heard together.
Third learned advocate, Mr. so and so with learned so and so. And learned advocate, Mr. So and so with the respondent. This the writ appeal is directed against judgment and order dated 14th March 23 of learned single judge, whereby the writ petition is allowed and the following directions came to be issued in favor of the original writ petitioner. Then quote paragraph 62, 63 and 64 at page 79 and 80. Full stop. Having considered the rival submissions and the contents and the findings recorded by learned single judge, the court is of the prima facie view that the appeal deserves final consideration. Therefore, appeal is admitted. It shall be listed for final hearing in the week beginning from 15th July. Full stop. By of interim
Maybe
relief,
on June,
the-
my Lord, kindly.
by of interim relief, directions contained in paragraph 63 and 64 above shall remain state during the pendency of the appeal.
Can you post on June, my Lord, at least, my Lord? They have
No,
not
it-
given even medical
final
benefits
hearing
also,
cannot
my
be.
Lord. His wife is suffering from cancer, my Lord. Is in need of money, my Lord. They have not given. 2
Lord,
years, my Lord.
we have paid, my
Finally,
Lord.
finally will consider.
Lord, date may fix it on June, my Lord, kindly.
We have gratuity has been paid, my Lord, gratuity has been paid.
June, my Lord.
Provident fund has been paid. What has been denied is, my Lord,
In the
we
paragraph
have
59,
an LIC pension scheme, which is for executives. That, my Lord, because of dismissal, only that's only a very small sum.
After
Then
retirement, they have dismissed from the service, my Lord. After retirement. They have taken back all the benefits, my Lord.
Gratuity and other terminal benefits have been given to you.
yes, my Lord. In the affidavit, my Lord, along with the IA, I have already
Given,
stated.
my Lord, thereafter, my Lord, they have taken back, my Lord. The
No, I have not
laptop
taken
or
back.
Mobile phone, laptop and benefits, my Lord.
Directions in paragraph
Amount
62,
given to
63 and
the
64.
furnitures, my Lord, also
All.
taken back, my Lord.
62 also. Full stop. Before that, it was stated by learned advocate petitioner that the amount of gratuity and other terminal benefits have been paid to the petitioner.
Yes.
Yes, may kindly, my Lord, request
For the appellant.
I'm requesting for the short date, my Lord, in the June month, my Lord.
Learned advocate appellant stated that the gratuity and other terminal benefits have already been paid to the respondent petition.
Except, my Lord, EL encashment up to 80 days we have given that because of the rules, because of dismissal. And then, my Lord, pension has not been
No,
paid.
what you have paid, we have mentioned.
Yes,
Except pension.
pension and then certain medical benefits post-retirement, my Lord, they are not entitled to.
We are observing this only to balance our.
Very well.
My Lord, may kindly
Obliged.
request, my Lord, I'm requesting for fixing the date in the June, my Lord. Kindly. Some urgency, my Lord. June month,
Which date we have granted?
15th of July.
12th August, in the week beginning from 12th August.
June, my Lord.
Now you choose August or July.
July, my Lord. Can be heard along with the contempt, my Lord. 417 also there. Okay.
Final hearing can.
Number 16. Mr. Subramania R.
Make one submission in 16, along with 16, serial number 69. There's a common order, my lords, but two different issues. 69 also is there after my.
69 also connected.
Lords, it's a common order passed. 69, my lords.
This is the Rajiv Gandhi.
This
69 is
under the
Rajiv
Begri's
Gandhi.
Act, my Lord.
This is what?
This is under
the
prohibition of.
After it finishes, I can, the lordship takes up Rajiv Gandhi.
Notice.
Notice has, formal notice has.
Will file an objection.
But there was a stay order throughout the writ petition.
Both the writs, there was an interim order of stay we were operating.
Connected matter also, there was no stay granted.
In our
It's
case,
No, in this matter, there was stay.
There was stay,
No, it's
Manoj, but-
covered by several division bench judgments on the issue. Whether Lord's the nomination of the government by the government is under pleasure doctrine or otherwise. It's covered by several judgments. The learned single judge has followed that and has held that they are not entitled to continue.
that's my
Merely
learned friend
because-
appears for the university.
In our
Government-
case,
University can't have a stand in these matters.
It's all right,
It's
but
the
I should
nomination of-
assist the court. I'm made a party by my learned friends.
Now, one of the case you have reserved.
The provisions are slightly different from each one of them, Manoj. That's the.
Sorry, further hearing.
for
That
the-
is under the VTU Act, your lordships had dealt with yesterday.
But then
There are different, my lords, this one is under Beggars Act and the 69 is under VTU, the Rajuga. Different acts have different provisions. The learned single judge has examined, has applied division bench judgments. Lords, at the stage of preliminary hearing before the learned single judge, my Lord Justice Dikshit, my lords only made an observation that though covered by the division bench judgment, because of the corrigendum which said the period is altered, your lordships wanted to have a second look. The learned single judge has had a look and says, even that was in terms of section 21 of the General Clauses Act, which the order was also under section 20. You have copy of the interview?
Yeah.
Because it clearly says subject to the pleasure of the state government in this act, Manoj. Please, subject to the pleasure of the state government.
That is
Therefore-
different.
Therefore, it is very clear. to say
Different
that-
issues.
No.
ಯಾವ್ದ್ರಲ್ಲಿ ಅದು?
You should, Manoj, when they want convenient.
No, it's a, I said after
We
this
argued
because it's a
in
common order.
separate-
I'm not saying take it. Lords, it's a,
So
the judgment
therefore-
is a common judgment, common. Yes,
So
this
therefore-
is, that's why he, my learned.
So you should have waited
Language
for
is
his,
different.
you should have waited for his turn. He says it's club.
I said after this, it's a common judgment, my lords. My
On the
learned
lighter
friend
side,
can't
my
take
lord, I-
objection that I should wait till 69 if you
No,
want.
I'm on the lighter side, Manoj. Now that, Your Lordship, the section is very clear, subject to the pleasure of the state government.
In our case, Lord, when the interim order was granted, this court relied upon the Janardhanam's case where, Lord, this cannot be, this kind of an omnibus direction is not permissible. In our case also, I was appointed as the chairman. There is an appointment order. Nomination as a member followed by an appointment. And the period is generally for a period of 3 years. No doubt it says the term is subject to the pleasure of the government. But they can't be, a chief minister passes an order, whoever is appointed in the previous government should be removed.
As the chairman of the. In sixth. Petitioners, appellants herein.
Blood, this
Your Lordship, can it not club both the matters, my lord? Let it be dealt separately. My humble request is, my lord, when it is convenient, they argue before the court saying, let
He
me
did
complete,
not
my
ask
lord.
for clubbing, I'm sorry.
No,
We
because
argued
the
separately
reason is
only.
this, my lord. Their argument provisions are different, because of which the matter has been clubbed. So therefore, let it be taken simultaneously on the same day, but dealt separately, my lord. I have. Because ultimately, your lordship may be satisfied with one or may not, or be satisfied with both, my lord, so that interpretation of clause in each may be dealt.
Lord, your lordship referred to nomination to the syndicate. In our case, Lord, it is nomination and appointment to Central Relief Committee.
Chairman.
Central
At
Relief
the
Committee.
Nomination and
Shall I
appointment as
mention
chairman
it
of
that
Central
that
Relief
term comes
Committee.
to?
Syndicate oblique Central Relief Committee.
Syndicate, my lords, is for where I represent.
Like syndicate.
69.
In 69, it is nomination and appointment.
So
as
mention
chairman.
name of both the advocates and indicate oblique,
May I make one?
which is that
Central Relief Committee.
Central Relief Committee.
May I make one request? Lots of mentioned by way of an interim order to continue the interim order till the next date of hearing. The term itself comes to my lords on 12th of June.
Or till the expiry of the
Yes,
period.
your lords may
whichever is-
just add that.
No, my lords, that is also.
We can't have, my lords,
No, brother.
When it is coming to end.
That you cannot.
My learned
by
friend
way of
wants-
an
no,
interim order, he can't
lords,
have
the
an
university
extended.
wants to say it's a retrospective appointment from day
Whatever
before
is
my
the position in law.
That's to an end.
Yes, it's
When?
on the 12th of June.
See the appointment
2020.
order, my lords.
Your lordship may have it on 10th of June, my lord.
I have no issues. Before that, your lordships can continue.
So your lordship may say whichever is.
The appointment, my learned friend wants.
Only in his case, Lord, not in our case.
What argument? That's why I request.
Yes.
Please, that is why, that would be solve the problem.
Please.
Grateful to. My lords have not tagged the matter.
Yes.
Just
69
separate orders
is,
be passed, my lord. Separate orders.
but that's the syndicate.
That is
Rajiv
significant,
Gandhi.
this is beggary.
But on the same day, it can.
Here also you are appearing.
Pardon?
This serial number also you are.
No, not in, lords, what has happened, it's a one.
This name of Ashoka. Central voter.
69.
And syndicate.
6th of June.
Both on 10th of.
Please.
Separate.
Keep it with it, discuss later.
Lords, in 69, there is one office that
Office
I have,
objection you
no,
have to
that is, my lords, some of the petitioners have not challenged, so we have, my lords, said that we have put a note saying that we have not arranged them as respondents since no claim is. I have put a note in the cause title that we have not made them as respondents. Please.
Impugn is confined to the petitioners only.
Appellants.
Appellants only.
Naturally. Interim orders are otherwise said. They're confined to the parties here on.
Please, my lord.
Appearance matter, seal number 17, sumo to criminal contempt.
I am for the complainant, my lords.
after vacation.
May I make one submission, my lords? He has filed memos, my lords, dated 1/4/2024. In fact, those memos also amounts to contempt, my lords. It gets attracted, my lords.
Is stage of framing of charge.
The accused.
Yes. 13th June. The complaints in contempt matters, cell number 18, Mr. Govind Rajke.
Lord, the order is complied with, but my grievance still subsists, my lord, with liberty to challenge the order. States that the order under contempt he stated that since the complaint is agreed by the order, as per the authority, liberty may be reserved for the LMP side. And the order of the directions in the complaint complied with from the person will not survive. Same time, liberty is reserved for the complaint to institute independent of LMP order in accordance with law. This court does not expect of the subject as well as in respect to the recourse which may be contempt of that is called for doing so. Subject to evaluation.
Number 19 and 19.1.
Appeared for complainants in both the cases.
Not,
The compliance is not done there.
We have filed complaints affidavit on the last occasion.
Last time I submitted to your losses that the
There was a
competent authority is only the state which is required to take a decision in the matter with reference to the direction issued by the division bench. And now the order communicated is that of the director. Director is not supposed to
The
take any decision.
director is the appointing authority, so far as pre-university lecturers are concerned.
The rules are made by the state government, not by the director.
Said by wrong authority.
Your last may kindly see the direction issued.
No, assuming that it is true, your version is true, that can be a ground for adjudication in regular, not critical examination.
Kindly see paragraph 8 of the direction issued, page 19.
I'm producing the notification.
Only urgent matters were taken.
Number 20, hearing on application. Naveen Chandravi.
But this
Lordship, I put
arrangement
this for
was
further
made-
consideration today.
The arrangement was made, my lords, for some reason it has been posted today.
Matter is posted before the, to ascertain, other day, we said we wanted to ascertain
Lordship.
as to how parties are conducting themselves.
Lordship, there's one statement I want to make, Lordship. The husband did go to Goa to meet the children. Lordship has mentioned in the order that it's expected that he goes to Goa and stay as a family. Lordship, the point is staying as a family is not possible with her because of the incidents which has happened. So Lordship, for the sake of the children, we want that the matter should be, the children should be given their fare. They should be studying in a good school, etc. But as the couple, I think they've also filed for divorce. We've also filed for divorce. The fact of the matter, Lordship, there are several, not only the incident, after that, there are many chats which are so explicit, which is part of the record, Lordship, wherein she is going to the extent of saying that I have affairs with both men and women. She's going to the extent of sending semi-nude pictures to different people and extremely explicit. So, in this point, it's not possible for them to stay together, Lordship. And I think she will also say the same thing. But Lordship, my only humble submission
sorry,
is for the ethical and moral welfare of the children. Till the time the writ is not heard, let the children be brought to Bangalore at least, Lordship, till the next date of hearing. Children are right now in vacation. So let them come right now till the next date of hearing when the writs are decided, Lordship. Because there will
I
be no
think-
prejudice which will be caused to them.
I think after the chamber reconciliation, an arrangement was made and
When it is coming to an end, vacation.
4th of
plus
June.
an arrangement is made and an order is passed to that extent. Yes, my lords.
June.
No, 5th of May.
Let me.
May, she's supposed to come here with the children.
No, Lordship's question is
Vacation
4th of June,
comes to an
Lordship.
end when?
In
4th of
Goa, my
June.
lords.
So from
Goa,
now-
it's I think 19th April.
19th
From
April till
the
4th of
letter
June
that I
is-
submitted last time, it is on the 19th April. My lords,
Reopens or starts?
reopens on the 3rd of June.
4th of June, we said the last day last time.
So then we already provided.
That
Lordship.
arrangement is made now.
Arrangement is
Lordship, we
made,
are
my
saying
lords.
that because
Arrangement is
19th of
made.
April, the school closed there. The children can come right now, Lordship, till the next date of hearing, Lordship. My only humble submission is that the children should, because 4.5 months, the children have been with the mother exclusively.
No,
Exclusively.
No, it's not that arithmetical apportionment.
But Lordship, my only point,
And this, no, it's not that.
also Lordship, on the point of moral and ethical
After
welfare,
hearing
Lordship, the
both-
point is the children are with the mother. And if Lordship would just see the nature of,
Same arrangement will continue.
but Lordship, there's one submission, Lordship. There's a typographical error also in the order.
Court will continue to operate.
Lordship, there's a order.
Parties till the next, put up on 3rd June.
3rd June. Great.
Lordship, there's a date when on the 4th of June, the children were supposed to, 4th of May, the children were supposed to come to Bangalore because it was the grandfather's birthday, Lordship. Now, however, what's mentioned in the order,
This arrangement we have made after hearing all of you, even after
Correct.
chamber hearing.
That's right.
so Lordship, no, Lordship, the point Lordship had said that yes, because of grandfather's birthday, 4th of May, the children should come. But Lordship, in the order, which is why we think it's a typographical, which is mentioned 5th of May, when the
I
children
don't
come
think
back.
It is a typographical error. my
If
lords.
Lordship, if they don't have a issue with sending the children 4th of May, then no change has to be made here.
4th of May, children have to come to Bangalore.
That was Lordship fell from the bench also on the last time.
It's all that I can tell her, my lords. It's just a matter of a day. It's fine. Not
But then
an
Lordship,
issue.
And also, in fact, there is some indication justifying his submission.
No, my lords, it's just a matter of one day prior that she has to come. It is, anyhow, she has to be here on the 5th of May,
5th
I
of
think.
May will-
5th of,
But
One day.
4th of May is the grandfather's birthday, who's in Bangalore, Lordship.
it's,
She's saying she's
We
there.
cannot run the life by calendar. Life is different. The games of lives are different.
But Lord, it was
Calendar
agreed,
clocks
Lordship.
will not
It
much
it was
govern us.
agreed, Lordship, on that day. It was agreed on that day, Lordship, which is why it is being said. And
Grateful.
3rd of June, Lordship, for the grateful Lordship.
Number 21, Mr. Vijay Simha Reddy.
And for the complainant, the typographical error is at parrot 1 and 2 minutes. Instead of Bangalore Mahanagara Palika minutes, it is typed as Bangalore Development Authority minutes.
BMP, it should be.
Number 1 and 2 minutes. At page 2 minutes.
Instead of BDA, it should be BBMP.
Bangalore Mahanagara Palika. BBMP. BBMP.
Applications, right? It can be treated as being spoken.
In view of the error of transcription, according to ordered it. 5th April 54, the present petition which was closed to 8 days comes up for consideration. Notice that there is two. First line, the group of words for Bengali development of the it is wrongly translated. It should have been Bengaluru,
BBMP, Bruhat Bengaluru Mahanagara Palike.
There shall be substitution of words accordingly. And how to say it is accordingly.
Great. Great.
22 urgent, seal number 23. The N. Shreyas, party in person.
My lords, appearing party in person, my lords. One request, my lords. So I might be permitted to appear virtually because I've injured my leg, my lords.
Tender process is on now.
No, tender process is over. We have fixed the, we have.
You have
procured
fixed
the-
also.
We have fixed the, procured the equipment and we have fixed the equipments in the 944 buses as stated before the court.
Out of?
944 buses, we are required to fix it.
No, how many buses you are having? You cannot be
11.
selective in implementation. All buses will be used for commutation. How many
Yes.
buses you are having?
Total number of buses. I have filed the affidavit on 18th.
You're asking the number.
Suddenly- No, yes, that is true. What was submitted on that day is that we have total number of buses 6,334.
6,334.
Out of that, 2,685 buses were functional as on 7/11/23. Thereafter, we made 700. 2,685. Which were functional as on 7/11/23. After 7/11/23, we have made 897 buses as functional.
So in
thus-
3,649 buses, you don't have that facility, going by your arithmetics.
No, 3,582 buses.
No, you said, I have done my rough arithmetics.
2,685.
6,334 buses you own. Is it correct?
6,234 buses we own.
6,234.
234.
234.
Yes.
Oh, I got it from.
3,549.
Out of which 3,500 was functional as on that day.
Now they are not functioning.
No, they were functional now.
Functioning now
They are
also.
functional now also. Now thereafter, we were required to make it the functional about 944 buses as per the affidavit filed on that day.
Is it in addition to objectives in all buses that
Yes, yes, that
facility?
is
It
true.
cannot be selective like that.
No, we have so far as except the buses which are selected to be scrapped, everything is completed. We have
How many
given
buses you have earmarked for scrapping?
1148 buses were selected for scrapping.
1140, out of 3,545.
Out of
685.
2,562. 3,582 were functional as on that day. Para 3, my lord.
3,582
were functional.
82 were functional.
As on that day.
Yes.
So
Then,
out of that, the
scrap
remaining.
value, tell me the number of buses earmarked for scrapping.
1148. I've given the table of dates of scrapping.
2,434 buses are available.
476 buses, they are old model. They are also, because the bodies which are built then will not permit the voice installation. Therefore, that was not fixed. That are also explained in para 7. So what was required to be done is 944 buses, we have fixed it. Out of 1148, we have scrapped 214 buses already. Remaining 934 will be scrapped in the course of time. And we are procuring 1140 buses. I have produced the tender notification issued and all that. All will be.
Buses which are plying, barring
Except-
those which are,
Except all
old
buses
body.
all buses which are playing are fixed with the voice and system, except the buses which were selected to be scrapping as stated in my affidavit.
Affidavit dated?
Dated 18th December. 18th December. 18 December.
December.
My lord wanted to indicate the timeline. Therefore, on 18th.
We are asking you, simple question.
Yes.
2012 to 2023, we had made an order.
Yes.
Is it complied with?
Yes, we have complied with.
You have complied with. What is, do you vouch that version?
No, I need to verify
You are
that
the
from the
state.
BMTC's point of view. I need to verify that. I have no reason to doubt it, of course, but I'll have to cross.
I have supplied a copy of verification. What is it?
Copy? File it.
I have given.
But your officer will head all these corporations.
Yes, we will verify that. May I suggest one more aspect? July.
Still, they propose people to these corporations. Passport corporations. But the reading may be required if he says he's true. Maybe required.
The subject matter of this public interest is
We'll keep it in the file.
resumption of services of audio announcement system in BMTC buses for the benefit of visually impaired. Differently abled persons. Now it is also not different. Differently abled persons.
More particularly,
the issue was
particularly
considered.
vision impaired persons. Meant for.
Both words are used.
Which is the other word?
Vision. Visually impaired person.
Even better word is going.
Yes,
differently
Just not able to
differently,
recollect.
correct.
Differently able.
Full stop. Full stop. The issue was considered in the context and in light of the earlier order passed on 28/12/23. For some time with the assistance of learned counsel separating the parties. Since this would require further response at the end of state government.
Yes.
And further deliberation also, further consideration also, put up for further consideration on.
Whichever date, because you said you will vouch.
Yes.
Or do not
May I
vouch.
suggest first or second week of July? I'll also explain why, Maras, because on the previous date, we had filed a memo for private bus operators that the timeline fixed was 30th June. So possibly I'll be able to assist my lords insofar as that
5th of
timeline.
July.
5th July.
Number 24, Mr. G.R. Mohan.
Grateful, my lords.
Appearing for respondents 1, 3 and 4. my
Pertain to the redevelopment of Gandhi Bazaar main road by the fourth respondent. Now, the problem is that I have asked to file the points for consideration.
Maybe,
I have
yeah.
filed it.
We'll
Now,
apply-
already 6 deaths have taken place because the road is so narrow. Yes, Your Lordship. They made it, earlier it was 80 to 90 feet, Your Lordship. Ambulance cannot pass through, a lot of problems are there. So, because that is why I asked to file a points for consideration, which I filed.
We'll have it immediately.
Immediately application, Your Lordship. Because already 6, 7 deaths have taken place, Your Lordship.
After it.
Immediately after the.
Say 11th June.
Applied.
Still number 25. Yes, Muralidharan, party person.
Milord's animal activist from Chennai. I work for captive as well as wild elephants. This is a public interest litigation long pending. Praying for shutting down an illegal elephant camp in the state. And there was some clarification required by the lordships. And now the central government themselves have written to the state government saying it's illegal. Subsequent to that, the Supreme Court also has reiterated what they said in year 2000, that no more rescue centers or zoos should be established without their consent.
What happened to identical matter that was pending before the larger bench of the apex court?
There is not in this issue, Madam Milord?
In this issue only.
No, Milord. There's nothing pending in this issue. This is a specific to Tamil Nadu, Karnataka state government.
Yes.
Lordship, I have filed some annexures on 8/4/2024. Lordships might have it. It's in e-filing.
We put up after vacation. Find out what is pending before the Supreme.
No, Milord, I'm aware of that. So this is a letter come from the central government. Lordship may look at it.
But anyway, today vacation, only one
No
day we
time.
are working.
The
Very urgent matters.
notices are not served from 8 months onwards, Milord.
Okay, sir.
We can complete serve.
This heard party in person, learned party in person, notice written.
My lord, I take notice for respondents 1, 8 and 9.
In fact, the apex court has reiterated 3 weeks ago that no zoos or rescue centers should be permitted across India.
So we are issuing notice. We can't say no to elephants.
No, he's a repeat offender, Milord. He's already reprimanded by Madras High Court. There are many allegations.
8 and 9, you are appearing.
1, 8 and 9.
1, 8, 9. Yes.
So returnable on 19th June.
Much obliged.
Still number 26. Mr. Chandrasekhar Reddy, Arya.
Appellant in first matter, my lords. Appellant is no more, my lords. Filed an application to. Lots of appellant filed an application to come on record, my lords.
Appellant has died.
Yes, my lords.
First matter.
First matter, my lords. That this honorable court allowed the application on 15/4/2024. By mistake, my lord, it is not typed in the order sheet. My lords.
It is not allowed.
Noticed in the pleading of the appellant as well as the respondent, from both of whom wants to implead the legal representatives of the deceased appellant. Full stop. One of the party has proposed 4 legal representatives, where the other have 5. In that view, the order passed earlier dated is recalled. Full stop. Both the applicants will be relisted for press consideration on 11th of June.
This is that
Soma.
matter, my lords, where Mr. Ravi Shankar had assured
On which
that
date
there are
we-
number of parties and they will give a tabular column.
No.
Then large number of the connected appeals.
The PWCC Act, what is that is same matter. On which date the parties will
After
verify
vacation.
the factual position.
Please.
My lord, that is recalled. It is not
Chart
signed.
is ready, my lord.
Not signed. Let it be remain unsigned on the.
My lord, senior.
Yes. Sign the same date.
Chart is ready, my lord. Where last occasion, the lordship direct me to file in a charge sheet.
Steps to be taken in respect of answered several respondents, no?
That's why, my lord. Everything is mentioned in this chart, my lord, because
All right, but-
other appellants are filed the appeal, no, my lord. So that's why I mentioned everything in this chart, my lord.
And then next date we can look at. Next date, we will just serve copies with the, to the other side,
Yes, ma'am.
on the other side.
First. Interim order next.
Interim order is there.
Yes, my lord.
Next.
Number 27. Mr. Janardhan Ji,
In this matter, not in the connected matter, I appear for appellant. It requires some time,
Unfailing of
Lord. You'll ask
compliance
me
in
kindly
contempt.
have it after vacation.
After vacation.
Yes.
That no, that order, Lord, what I sought for is from UGC PCL from 93 from the date of confirmation of my order. But they have granted,
Your voice is not audible, it's weak.
Lord, that I have sought for, Lord, my order has been, my appointment has been confirmed by the government, Lord, from 1993, from the date of appointment as per the Lord, single judge.
We'll have it after
But
vacation.
I
Because
only one,
urgent matters. we
but
have
I
to-
only
pending matters.
one request, Lord. I not that, Lord, what they have granted. So Lord, as per that, whatever I am entailed for further promotion, let them consider that, Lord, let them not.
Next date we will consider.
The date.
Amendment has to be filed. In connected matter.
Date is given.
Some amendment needs to be done.
But I am not, we will have to.
It's your matter.
Yes. I shall.
Whatever
do it.
complaints to be done, do it. Before
Fine.
next date of hearing.
Please.
number 28, discussion number 29. Mr.
All
Joseph,
contempt up to 42 are adjourned.
Adjourned, please.
Unless they are complied with
Petitioner.
tables. Any up to 40.
Lord, 30 and 31, Lord, we have sought for 4 months' time. Lord, to comply the order, that may be disposed.
On that day, you repeat the request.
Please.
Lord, 33 and 39, they are interim orders. In identical matters, lordships have disposed of the matter, Lord, granting them liberty to move the concerned bench. I pass on. 33
I
and
am a preferred
39.
complainant, my
They are
lord.
on
The
interim
similar
orders.
matter, my lordship was concerned, my lord, page number 30.
Hearing of your counsel is.
My lord, page number 36 may be taken, my lord, in this division bench, my lord, where the transfer has been done, my lord, is placed back to the position, my lord.
Identical matters are
Page
disposed
number
of. I pass.
36 may be taken, ma'am.
That is the after. All up to 42 after vacation. All contempt. 43 PIL.
the ready notice matters, seal number 43.
Petitioner's notice. Petition is filed challenging the amendment by the KERC.
After vacation.
Please.
37 may be dragged with writ appeal is filed.
37.
Ah.
Serial number 37, writ appeal is filed. This case may be tagged with writ appeal number.
Contempt matter.
Yes.
To be tagged along with writ appeal.
Yes, ma'am. We have filed.
Which is that serial number?
22.
37.
27.
37.
37.
Yes.
So 371.
Where your name
This
itself
contempt
is not-
petition shall be listed along with writ appeal number
1384
of 2020.
138. Give.
No, no.
Serial number
We know
30,
you make a
Lordship.
All contempt urgent.
Serial number 36, my lord, there is change in incumbency, my lord. The KPSC secretary has been changed. If your lordship could permit me,
Application.
Everything after it.
Only urgent
Number
matters. Court is
40,
working only one
44.
day, next tomorrow.
38, we have filed wakalat, my lord, in the matter today.
Verify with the register.
38.
Verify with the register.
Same, Arjun.
Pavan Chandra Shetty.
My lord, for serial number 44, my lord. My lord, we are challenging the sketch which has been carried out, my lord, which is not in lieu with the directions given by the then Mysore Maharaja in 1915. First of all, the sketch has been carried out after a period of 100 years, my lord, more than 100 years. And it is not done as per the directions and is not as per the village map either.
It requires consideration.
Which is this?
Prayers are vague.
Will consume time also.
My lord, the directions of Mysore Maharaja is at annexure E. My lord, may kindly turn to annexure E, my lord.
That can be considered after.
After vacation.
My lord, I pray for an interim order, my lord. I have secured license for quarrying
The
and
prayer
crushing.
itself is not maintainable.
My lord, if I may read my prayer, my lord.
That we will do after vacation.
I'm seeking to set aside the sketch not being in tune with the directions of the Mysore Maharaja directions, my lord.
That needs to be examined. Before.
My lord, in the interim, if my interim prayer may be granted, my lord, I had in 2014-15 itself secured all the NOCs from the
Keep
respective
it on
departments.
4th of June earlier and hear you.
Serial number 45. Mr. Dimantika Gowda. 45. Serial number 46. Steswai Shivalli.
But pity. One thing is, Lord, I'm seeking a writ of mandamus to consider my application.
Beyond.
After vacation. Number 47. Mr. Rajesh Gowda. Mr. Rajesh Gowda. 48, 49 are urgent. Seal number 50. Srijant Babu.
The short issue involved in this is whether suit, appeal, any case filed against a dead person is maintainable. My lords, the law is very clear. We have produced the judgments before the learned assistant commissioner also. Judgments of this high court also saying that appeal filed against a person in the year 2022 who is dead in the year 1991, it's a nullity. The person who has filed the appeal, he is well aware that this man is dead. In spite of knowing, he has filed this appeal. And who has brought this to the notice of the assistant commissioner is the children of the defendant.
51 delay. Notice.
Delay we can.
Notice was issued, my lord. Respondent has filed wakalat.
My lord, I appear for respondent number 1.
Or learned derivate Ms. so and so and learned additional government bidder Ms. Neelofer Akbar for the respondent state. Notice is out to respondent.
To one, there is only a second respondent
However,
other
nobody
than
has chosen to
the
appeal.
state.
Full stop. The application makes a prayer to condone the delay of 61 days. Passage of time leading to delay to the opposite extent is explained in the supporting affidavit. Sufficient cause is made out. Delay is condoned. Application is allowed. Writ petition was listed on 26th of June. Writ appeal. Okay.
51 to
51 days, not 61.
51 to 53 are urgent. Seal number 54. Mr. Sanjeev BN.
Contempt can wait.
Sanjeev Bial.
After vacation.
After vacation, Sanjeev, after.
Number 50.
In which matter?
54.
54 is the contempt,
My lord, there's a writ
coupled with,
petition also.
Take your time.
connected writ petition, there is the interim order.
This is the matter, my lord, which my lord.
Lords, the,
I have passed it.
no, no. Lords, it's passed by a learned single judge. When the contempt came up for consideration, Lords, the authority said that there is a writ petition in which an interim order is passed. Therefore, we are unable to comply with the orders. It is for that reason the writ was taken up along with the present contempt matter. Lords, now, so far as the writ petition is concerned, the order which we have complained of as having been disobeyed was challenged by this very writ petitioner
Supreme Court.
in the
where
Supreme Court.
50,000 cost was imposed.
50,000 cost was imposed. He suppresses the fact that he's only.
It's directed to be allotted, not. Yeah, I don't want to.
My lords had directed us to take a decision in this matter. My lords, the matter is by tomorrow, actually the date was given tomorrow, my lords. My lords may kindly take it up tomorrow. We'll place on record the decision taken by the state.
Please, my lords, tomorrow.
Great.
Copy of the order to be served on.
We will serve it.
To Lords, browbeat the existing bench, saying that one of the members should recuse. The same thing they adopted before this honorable court.
Let him not
When
try to
I
make
want,
one-
I want to make this statement.
It should not be.
When the Supreme Court
matter
said-
is adjourned.
Very well.
Lord, and yes, my lord, cost was imposed. I have
Cost
paid.
was imposed,
Yes.
50,000 cost was imposed.
I have paid the cost.
By
I have
the
under-
apex court.
Lord, I have committed a mistake. I have not undergone the punishment. I have paid the cost. I have been penalized. I have paid the cost.
But things are not that simple, this much.
Yeah, yes, my lord. Matter requires consideration, Lord. I will not, Lord, I will not, my lord, say for a moment that it is a simple
Anyway,
matter.
tomorrow matter.
Tomorrow, Lords. Grateful.
Grateful, grateful. my lords.
Interim order has to be. Writ
Yes.
petition.
Interim orders will continue till.
Please.
Great.
Number 55. Ajay Jain.
Item minutes before the learned single judge minutes where the undertaking was given on to precipitate is listed today. May I request for the matter to be taken up immediately after vacation minutes. May I request for a date to be fixed minutes because.
All date.
Great.
All contempt may go after it.
Great.
56.
My lords, I appear for the petitioner. Lords, I understand that the respondent has been served.
Appearing for the respondent, my lord.
Which,
To file wakalat and my reply in the
which serial number?
56.
5-6.
56, my lords.
You appear for respondent.
Respondent, please. Undertake to file wakalat and reply by the next date of the.
My lords, it may be taken up immediately after
So
vacation.
what do you want? Complied with.
I'll file my reply.
Reply you want to file after it.
Immediate, my lords, a date may be kindly fixed, my
Date
lords.
will be given. Date will be given.
Grateful, much obliged.
Number 57.
For the respondent, I'll file a reply, my lord, next week.
Mr. Kempana.
for the respondent.
All will go
All
up to
all will.
64,
Up to
64, up to 60.
File a
Up
reply.
to 64 after vacation.
Yes. Wherever steps are to be taken, steps.
65. The CM Venkat Reddy.
Infectious.
Number 65.
My lord, myself, party in person, my lord, serial number 58. My lord, serial number 58.
Yes, sir, date is given. We are not
50.
taking it up
58 to 64 after vacation date will be
after
given.
vacation.
Number 65
Okay,
to CM Venkat Reddy.
Amendment.
18.
After vacation.
Number 66. Nanda
The
Kishore.
petitioner's minutes. Whereas we'll have to comply with the office objections. Kindly have it after vacation.
After, all after 20th. In July maybe, no? Because
Distribute.
67. So VB
Appellant.
Shivkumar.
Respondent, my lord.
You have to complete.
There is an
Wait
office
service.
objection raised as regards the wakalat,
Wait
my lord. I'll
service.
comply with the office objection.
Number 68.
My lord, this.
The interim order be extended, my lord. Status
Interim
quo.
order.
Yes.
in 67.
A
Yes,
date
yes.
be fixed in the matter, my lord, for.
Yes.
thing. After
Yes,
the.
we are agreeable. Again, argue.
Okay. I just want to bring to the notice of the court some facts, my lord. Great.
My lord, this matter pertains to the Karnataka. Yes, ma'am.
Vacancy.
Yes, yes. My lord, it's
68
maybe
called
posted on 18th June, my lord.
But
along with the
process has,
commitment.
they have to take steps. Service awaited, steps to be taken.
Steps to be taken for effecting service on the unserved respondent.
My lords, serial number 61, my lords, may be permitted to take file wakalat for A1 and A2.
Why permitted? You file wakalat, they will show that. No permission required for filing wakalat.
69 at 10. Number 70. 70 onwards. The office objections along with council submissions. Number 70. Number 70. Sirish Krishna.
This actually we have
70.
complied.
70.
All are office objections.
Office objection. Comply with that. That you have to consider.
For dispensing.
File.
Nobody is there. Barred by limitation. After vacation. So all office objections matter, time is granted.
77 after vacation.
71, my lord. My lord,
71.
71, my lord. My lord, council submission is that, my lord, the fourth respondent is necessary for the hearing of this contempt petition for the very reason that, my lord.
No direction against fourth respondent.
Please, my lord, the incidental compliance has to be made.
No, that will
The reason, my lord,
The authority will take care of. So you just comply with the office objections. Office objection to be complied with
Please.
in 71 within 4 weeks.
Serial number 79, Malan. I'm the party in person. The
appear
office
by the-
objection is that
yeah.
whatever I've stated.
You have to comply, yeah.
application has to be stated in the affidavit. I've said whatever stated in the
Actually, they
application is
paid
to be
on that.
correct. Written, my lord. The office
Comply.
objection will be overruled.
My lords,
I filed my IA to vacate the.
79 office objections are dispensed with.
my lords,
And
two
IA
more
to-
connected
I have filed
petitions.
my IA to
I'll
vacate the
file.
stay, my lord.
We'll see, we'll look into after
It will
vacation.
become listed next after vacation.
Vacation.
Two more connected petitions are there. Writ appeal number 490 and 491 in the same matter.
With this
Number-
matter, with
Yes, my
madam's
lord.
matter.
Yes, my lord.
So what is to be done there?
Maybe tagged together.
Along with it, we listed all together.
I filed my
72
counter
na?
affidavit also, my lord.
You do it.
My lords, interim order may be extended, my lords.
If it is there.
Yes, my lords.
you
My
action.
lord, the stay is granted against a contemner, my lord.
All right,
He has
all right.
not obeyed the orders of this.
All right, we'll
court.
consider all that after vacation along with 2 more matters.
My lord, the order, maybe I'm in financial crisis, my lord. I
All
had a fractured rib actually.
We'll have it after vacation.
At the
My
earliest,
amount
we'll
is
have.
held up with them.
Say
My
on
amount is held up with them.
18th.
18 June.
Serial number.
My lord, serial number 72, my lord.
18th May, my lord.
18 June.
June.
My lord, it is too late, my lord.
There
I've
is,
got fracture of my this thing, my
there is
lord.
a
My
vac-
amount is held up with them. My gold jewelry,
but there is a vacation, madam.
my lord, that's why I'm requesting, my lord, the amount whatever is deposited before this honorable court may be released.
My
to
lord,
me.
they are defaulted the loan.
No,
Conditional
not-
stay order was.
Amount towards what?
My lord, they are defaulted the loan.
Loan amount.
No, my lord, there was a stay, my lord. They actioned my
Requires
jewelry
consideration.
even in spite of the stay, my lord.
We will do after vacation, 12th June,
12th
earlier.
June, 12th.
And my lord, my financial crisis is, my amount is
But
there.
what
with
can
them.
be done?
They have actioned the gold in 26.
Then you move the
22, my
under
lord.
vacation, judge, if you want to.
Move the court, my lord.
You can move, no, nobody,
That may
please.
be returned, my lord, otherwise. there
We
is
will not
no
say, it
other-
is for learned vacation just to.
I
Interim
may
order
be
may be
permitted to
extended.
move.
Interim order may be
By
extended.
appropriate procedure.
Thank you.
My lord,
My
serial
lord,
number.
interim order may be extended. my lord. Interim order may be extended. my lord.
Extend out to 18th June, interim orders.
Serial number 72, my lord, I have complied the objection. In spite of that, my lord, I have shown I have not complied. There is a direct,
Number?
yes, I have complied, my lord.
Which one?
Serial number 72, I have complied. I have produced the.
70.
Yeah, 72.
72.
I have produced the representations also.
Council
Now-
submission.
Yes, my lord. I have.
It's on council submission, not compliance.
No, thereafter I have complied.
You have complied
Yes,
subsequently.
Yes, council submission and complied, my lord.
What was the objection?
Objection of production of annexures.
That you have produced.
I
now.
have produced now. Now there is a direction, my lord, to release the
72
arrears of
office
sale.
objection.
Submits, compliance, registry to verify.
Learned Advocate Mr. Padmanabh R states that the office objections are complied with. Registry shall verify the compliance
Yes.
and.
My lord, in
take
the
all-
meanwhile, there is a direction, my lord, to pay the arrears of salary issue.
These are
Notice
all
may be
pending.
issued.
Let us.
Let the registry.
My lord, serial number 75, I appear for the appellants. My lord, the office objection, my lord, is with respect to non-production of annexure U and W with the rejoinder. My lord, the rejoinder was filed by the respondent before the learned single judge. Copies of those documents were not served to me. Hence, my lords, I'm unable to produce them before your lordships.
No, you should get a certified copy of the documents and produce them. That's the law.
Please, my lords, my lords, interim order may be extended, my lords.
Wherever it is, it will be extended.
My lord, serial
Time is
I will.
granted, 4 weeks time is granted to remove the office.
My lord,
Please.
serial number 77, my lords. I moved court.
Grant time up to 3rd June in all.
My lord,
serial number 70, my lord, may I request for a date to be fixed, my lord?
Date will be given in each matter.
In every matter.
Please, great.
my lords, one submission. I appear in serial number 77, my lord. There is an imminent threat of dispossession. I had moved court day before yesterday, my lords. May I request the court to take it up, my lords? 77. The only office objection, my lord, says that statement of objections, the memo stating that statement of objections has not been filed by first respondent is stitched at page 429 instead of immediately prior to the wakalat. That may be overruled, my lords.
Instead of putting it up here, they have put it subsequent to certain pages. Or mistake.
Dispense, the office officer dispense.
May I request for the matter to be taken up, my lords?
Application.
My lords, there's an imminent threat of dispossession. That's the only reason. There's an imminent threat of dispossession as led by senior advocate Mr. Dhyan Chinnappa. Day before yesterday, he mentioned the matter, my lords, for hearing.
What is the subject matter?
Land acquisition, my lords.
That it can wait.
The office objection may be overruled, my lord.
Yes.
Great.
My lord, in serial number 78, I
My
appear for
lords,
the
my serial
appellant.
number is 74, my lords. The office objection is to clarify the accused name. And it is mentioned in the petition that is like, the name is Dr. Richard and D'Souza.
Have you mentioned the department now?
Yeah,
When did you do it?
yeah.
Registry to verify.
Learned Advocate Miss, what is your name? Good name.
Your name?
So and so stated that the office objections are complied with. Registry shall verify. If complied with, post the matter for admission.
My lord, in serial number 78, I appear for the appellant, my lord. There is an interim order that may kindly be extended, my lord.
Wherever interim order is there, we extend.
Grateful.
78. Like serial number 40, please.
Serial
Yeah,
number?
After vacation. Serial number 40. After
It's
vacation.
a civil vacation.
There is urgency.
Date is given.
Final reading matters, serial number 80.
Appearing for petitioners, my lords.
ETN also.
Matter might be taken up post vacation, my lord.
After vacation. All after vacation.
51 urgent, 82. Sit For down the
uh,
on the P.
appellant in this matter. This matter pertains to NTI society plus not.
Disabled. Other bench. I was there.
Serial number 83.
Obliged.
I appear for the appellant.
Petitioner.
I appear for the petition.
By 83.
After vacation.
Yes, ma'am. I appear for the revision petition. Last may kindly have it up.
Date may be given.